started. Thank you all for being here this evening. My name is Amy Petaloo, and I'm a postdoctoral researcher at the Australia India Institute. And to just give you a sense of what today's event is part of, the Australia India Institute has a series called the Question Mark Series, which is really about looking at global challenges and issues in the world through an Indian lens and thinking about what we can learn from India about those issues. So the question that we're asking today is, how is India changing the global discussion on transgender rights? So this series, you'll see several of these around if you follow our website and Twitter and Facebook, which you should. See, I'm good at sales pitches. But they fall under four areas. They fall under education, health, infrastructure, and governance. And so today's talk is falling under this theme of governance. And really for researchers affiliated with AII, this is about engaging with these kinds of questions that provide vital place-based understandings of the complex challenges concerning governance, prevailing not only in India, but also regionally and globally. So before we get started with the panel discussion today, I want to acknowledge that we're meeting on the unceded territories of the Wurundjeri people of the Kulin Nations, and to acknowledge their elders past, present, and emerging. For today's discussion, we're focusing on that question that I mentioned about how India is changing the discussion on transgender rights. And this is based on a Supreme Court decision that happened in 2014 in India that passed down a landmark judgment on transgender rights. And in the conclusion to that decision, the court gave 9 specific commands to the government of India, which were aimed to improve the legal, social, and political situation of transgender people in India. So what we're going to talk about with our panelists today is a bit about that decision and those commands, but particularly how those might resonate or reverberate in other places and contexts, as well as this kind of global conversation about transgender rights and how that affects lived experiences and substantive rights as well. So I'm going to stop talking, but quickly introduce our panelists and then pass it along to them. Our first panelist and co-chair of the event is Dr. Jeff Redding, and Jeff is also at the Australia India Institute as a senior research fellow and a senior research fellow in the law school. And Jeff's research interests are in the areas of comparative law and religion, Islamic law, legal pluralism, family law, and transgender rights in South Asia. And then next in the panel is Michelle McNamara, who is an out and proud transgender woman who's active as a committee member in both the Australian GLBTIQ Multicultural Council as well as Transgender Victoria. And Michelle's been active in campaigns for transgender rights across Victoria for several years. Our next panelist is Dr. Ben Hegarty, who's a research fellow in Gender and Sexuality Studies at Deakin University and an honorary fellow at the Asia Institute here at the University of Melbourne. His Ph.D. research on transgender femininity and national modernity in Indonesia appears in Transgender Studies Quarterly and the Medical Anthropology Theory journals. There's more to all of these folks. They'll tell you more about themselves as they're speaking. And then last but not least is Dr. Joe Latham, who's an honorary fellow in cultural studies at the University of Melbourne. And his research combines science and technology studies, feminist theory, and literary studies to critique the medical management of gender dysphoria via the lived realities of trans men. So please welcome our panelists and let them tell us more about this.
Okay, so I'll kick this off by summarizing the ELSA decision. So for those of you who are not familiar with it, it's about a 200-page opinion. And so what I'm going to try to do is summarize it and explain both some events leading up to it, key features of the opinion, and what you might consider the afterlife of the opinion, and what it has sparked and changed, and some of the failures of the opinion. And I'm going to try to do that in 10 minutes. Okay. So I think the first thing to realize is that this is a really broad-based decision. And as you can see from the 9 commands in front of you, in this decision, the Supreme Court took on multiple forms of social and governmental discrimination against India's transgender citizens and declared them unconstitutional under various provisions of the India Constitution. For those of you who are Indian constitutional geeks, Articles 14, 15, 16, 19, and 21, dealing with both privacy and multiple forms of protections to to be free of discrimination were invoked by the Supreme Court, and the right to life. I don't want to go into the details of that here, but we can talk about it in the Q&A. But right, this was, the Supreme Court did a lot of heavy lifting in this decision, and it saw its task as really an immense one, and it described, how Indian law, and I'm quoting here, the Supreme Court was looking at Indian law and said, Indian law on the whole only recognizes the paradigm of binary genders of male and female, based on a person's sex assigned by birth. And this affects the law relating to marriage, adoption, inheritance, succession, or taxation, and welfare legislation, right? So it saw this, entire social and legal and political organization premised on binary gender assigned at birth, and thought, okay, in this decision we're going to take on all this and try to make things better. So that's, I think, one big aspect of the opinion to keep in mind. The other thing I want to emphasize, and this goes to some of the background and events leading up to this was not an opinion about sexuality rights, at least on its face. And at multiple times in the opinion, the court said, listen, we know that there's been this entire discussion about this provision of the Indian Penal Code called Section 377, which criminalizes same-sex sexual interactions, or at least those between men. And we know that there's been litigation on this and pronouncements from the Delhi High Court and also other benches of the Indian Supreme Court. We're not touching that, okay? This is about transgender rights. This case is about, now, whether they were successful in delimiting and sort of making that boundary, or whether anyone can really make that boundary, is another question. But they did not want to touch what that minefield, or at least as they saw it. This opinion also was not really one about gender broadly conceived. And so I have a piece that's coming out which is about this. But for those of you who are familiar with, and maybe no one in this room is, but for those of you who are familiar with this U.S. Supreme Court decision called Price Waterhouse versus Hopkins, in this U.S. Supreme Court case from about 25 years ago, the Supreme Court of the U.S. really was trying to take on sex stereotyping and governmentally enforced ideas, or privately enforced ideas, nonetheless illegal ideas about how men and women should look, behave, dress, comport themselves, and so forth. And this decision has sort of transformed itself in the U.S. from being simply a sex discrimination case to a larger case about gender, transgender, the gender spectrum, etc. But the Supreme Court in this case, I think if you read it, what comes across is this is about protecting the rights of a third gender. It's not about men and women so much in the relationship between men and women, but it's about this third gender in India, or third genders. That's maybe a more complex discussion, but I do want to emphasize that the Supreme Court in this case made pained efforts to say this is not about this debate in India about Section 377 and whether or not it's unconstitutional for the government to penalize or criminalize same-sex sexual interactions. And in fact, right, this decision came down in 2014. Just in 2013, the Supreme Court of India, reversing the Delhi High Court, this is complicated, but reversing the Delhi High Court had said the government can criminalize same-sex sexual interactions. So, in 2010, the Delhi High Court had said, no, the government can't enforce this British colonial era criminal statute, penalizing same-sex sexual interactions. The Supreme Court steps in 3 years later and says, yeah, we can. And so there was really sort of a moment of deep pessimism in the LGBT community. And then all of a sudden, 2014 comes along, and the Supreme Court issues this 200-page opinion, with these broad-based commands saying, government of India, you have to do better by your transgender citizens. So, people were left very confused, and I think the confusion continues. I'll just add as a footnote, just 2 weeks ago, the Supreme Court of India has decided to revisit and did hold oral arguments on its prior decision from 2013, and it looks like the Supreme Court is finally going to say that Section 377 of the Indian Penal Code is unconstitutional, but everyone's waiting still. The last sort of background aspect that I want to emphasize about this case is that this came relatively late in the South Asian context. So Nepal in 2007, the Supreme Court of Nepal in 2007 had already spoken broadly on the rights of persons belonging to, as the Nepal Supreme Court put it, the third gender. And the Supreme Court of Pakistan from 2009 to 2013 held a number of hearings and issued a number of orders concerning the social, political, and legal rights of transgender persons in Pakistan. So we have Nepal in 2007 and Pakistan in 2009 and India in 2014. Okay, key features of this judgment. And again, the 9 key commands of the court are in front of you. And I think if you look at those, you'll see that the court is speaking to the political, legal, and social position of transgender persons. Okay, so it's not just about rights in the classic or liberal sense of the word. And you'll see on that list that at one point the court directed that the center and state government shall take steps to create public awareness so that transgender persons will feel that they are also part and parcel of the social life and not be treated as untouchables. And in using this word untouchable, the court is referencing a long discussion in India about the social treatment of people belonging to the Dalit caste and other, this is to use Indian legal term, other backward classes. And in fact, Article 17 of the Constitution of India declares untouchability in this country, right? This social discrimination against people belonging to the lowest caste in the Hindu tradition. It's abolished, and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. So, right, the court was not just, this was not just a decision directed at governments, whether in the states or in the center. This is directed at society, this is directed at families, this is directed at parents, this is directed at people on the street. You cannot treat people in this untouchable way, and no matter how they identify gender-wise. The other thing I think that needs to be emphasized is this decision really looked to international and comparative experience. There's an entire section of the opinion which says, all this case law from all these jurisdictions supports moving in this direction. And in fact, they look at and cite 2 different Australian cases. The 2011 Australian case of AB versus Western Australia, and a 2013 New South Wales Court of Appeal decision, both concerning the right to change one's gender on official governmental documents and registries. So Australian precedent worked its way into the reasoning of this opinion. The last thing I'll say about a key feature, I think this is a case in which you really see sort of the indigenous quality of transgender life in India featuring quite prominently. And the court really spent time talking about how the Hindu tradition and to a lesser extent the Jain tradition and to an even lesser extent the Muslim tradition in India had a long history of recognizing people who identify in a way other than male and female. And in doing that, I think the court was saying, okay, even though we're invoking all this foreign, international, and comparative experience, this is an Indian discussion, and we as Indians need to treat our fellow Indian citizens better, right? These are not strangers, right? These are not foreigners. These are not, to invoke another discussion in India, invaders, right? These are everyday Indian citizens, and we need to do better by them. In closing, I'll just say, in India, there's this decision spurred a different legislative proposals. So there's been different bills proposed in Parliament and a lot of controversy about the contents of those bills. So Parliament looked at the decision and said, okay, well, we need to sort of take this 200-page decision and reduce it to enforceable text or clearly understandable directives. And that legislative debate still has not been resolved, but interestingly, one of the bills that was proposed in India was then picked up and used post-2013 in Pakistan and proposed in the Pakistan Senate, and all the provisions in the bill in India that mentioned India were just that India was cut out of that and Pakistan was put in it. So the exact same bill, Pakistanified, was presented to the Pakistani Senate. Now that bill was problematic in the Indian context because it was setting up these district registration committees in which some sort of committee was going to be able to decide your gender. And it was problematic also in the Pakistani context with what the Supreme Court was trying to do there. But it did spur a really large and interesting public and parliamentary discussion in Pakistan. And in fact, in 2018, a very different and a much more progressive bill was passed by both the Senate and the lower house in Pakistan and is the law of the land. So this is the Transgender Persons Protection of Rights Act, and that was passed in early 2018. And, however, in India, the legislative discussion continues. It hasn't been resolved. So I'll end there and turn it over to the rest of my panelists.
Okay, I guess it's me. So I'd like to indulge myself and offer my acknowledgement to the traditional owners of this land, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past, present and emerging. I also would like to pay my respects to brother boys and sister girls, the original inhabitants of the land on which we meet, the original transgender inhabitants of the land on which we meet, and pay my respects to them for their unique contribution to diversity on and about the land. They have existed for time immemorial as far as we can tell. There's been a lot of erasure of their history, and they deserve our respect as well. I think one of the things that I would like to start talking about, first about myself, I'd love to say I'm an out and proud transgender woman again. I know it's been said, but I just love it. You know, that owning my identity is incredibly important as a transgender person. And I think I should talk about gender identity a little bit. I'm not sure, are we all gender experts in the audience? Are we all, no? Yes? No? Okay, well look, I'll give it a go anyway. So, you know, and I'm not a gender expert, I should say. You know, I'm humbled to be part of this panel because I've got gender experts on my left, a legal expert on my right, an India expert here, and Pakistan with Indian expertise all around me. And I've been to India for 2 weeks once on a work trip, so I know very little about India. But you know, I think I should draw out the question of gender identity. To me, my gender identity is something that sits in my head. It's not between my legs. It's not my genitals. It's something that's inside me. It's an innate, felt sense that I am, in fact, a woman, even though I was assigned male at birth. That is different to the experience of an Indian hijra. And I think, from my little knowledge of transgender Indians who I've met here, modern Indians, there are modern Indians who aren't hijras who do identify as trans. So I think that's a complex difference between Western notions of being transgender and the hijra tradition in India. But the hijra tradition and the existence of trans people across the globe, traditional societies of transgender people across the globe, speaks to the validity of transgender identities. It supports me in my identity very much. And so when I first came out, I started reading about traditional transgender people, so reading about the Fa'afafines, reading about the hijras. The Fa'afafine are one of the transgender peoples of the South Pacific, or the Pacific Islands in general. Hijras, of course, being India, Pakistan. Then there's Two-Spirit in North America, and there's some traditional transgender people in Mexico. Across the globe where there hasn't been extreme suppression, transgender people have had a long, long history. And I think, you know, that speaks to the universality of the transgender experience and the validity of our individual identities. I think, having read about it, that's great, but then, you know, going out and meeting a Samoan person who said to me, you know, I said, they're a bit of a pop star, and I had a selfie taken with them on my first outing in a straight bar, and I said, surely you don't mind being photographed with a transgender person? And Kylie said back to me, no, not at all. You know, the trans people are part of our village. You know, they're part of family. You know, they have honoured positions in our society. No, of course not. Don't be stupid. You know, it's natural. You know, I'm meeting Indian transgender people, meeting Fafafine from Tonga, meeting transgender people from all over the world has been an extremely affirming experience for me. I think I said I'm not an expert about India, but what I've done is I do the social media posting for Transgender Victoria, and I followed with absolute fascination and interest the legal movements across the Nepal, Pakistan and India that I've referred to, and you know, it's been quite a revelation that third gender recognition is spreading across that subcontinent. I guess that on reflection, I thought, what the hell am I going to talk about in this lot as well? So I've talked about the gender identity and the validation that gender identity gives. I think, you know, looking at this broadly, the one thing that Australia and the Australian experience shares with the Indian experience is that we both have a British colonial history. And the British have not been proud bearers of LGBT rights around the world. In fact, I think being male homosexuality is outlawed in 35 of the Commonwealth nations still today. So there's quite a strong suppression of being LGBTI in the British world. And, you know, both ourselves, Britain itself, ourselves and India are still struggling to shrug that off. We are more advanced than India in legal terms, in terms of we legalised male homosexuality in this state in 1981, and in Britain it was somewhat earlier, I believe. But we're still struggling with the history of that stigma sitting there. I think when you look at transgender rights and acknowledgement of transgender rights and identities, even in this country, it's been a relatively, pardon me, longer road than male homosexuality. So the amendments, the primary pieces of legislation that give me my rights to my gender identity and my access to gendered spaces according to my gender identity rather than my sex at birth is in this state the Equal Opportunity Act of, whatever it was, 2010, right? Yeah. And the Commonwealth Act, the Commonwealth Amendment of the Sex Discrimination Act, which was enlarged from discrimination on the basis of sexuality to include gender identity, and that was only in 2013. And when you talk to transgender people around the state particularly, but across Australia, the improvement in acceptance of transgender people has come in that time. The acceptance of transgender people is increasing in this country, but there's a real kind of breakpoint around those two acts. And the act of giving us rights does not create a welcoming society necessarily, but it seems to be a natural precondition for doing so. And I think that it has shown that effect here. When I got the brief to come and speak to you today, I'll look at this decision in detail, and I have certainly appreciated Jeff's summary, because that 200-page document is not something I'm ever going to dip into, I don't think. But, you know, when I looked at that, I thought, well, this is great, but what's happened? Have they actually followed up on any of those actions? As Jeff described, they have not. And even more than that, when you start to look at press stories and information about how transgender people are treated in India, you find that their rates of illiteracy are something like half the general population. Their rates of unemployment are massively higher than the general population. They suffer discrimination and abuse at all levels of society across the board. Their acceptance hasn't improved all that much. Although, on the other side, you get the high-profile cases. So the first transgender Indian beauty pageant was funded by a private individual, has happened. There are first Indian transgender models, Bollywood actresses, train drivers in, I think it's Kerala or somewhere, some state in India. there's been a flood of those sort of stories coming through where, there's breakthrough events in the transgender community in India, as indeed there is here. There's breakthrough events here all the time. More and more people are coming out and declaring openly that they're trans in all sorts of levels of society in Australia. So I think this case and the follow-up legislation will be a really powerful thing for India transgenders, but it also echoes itself across the world. I draw comfort from it, and I can, we Transgender Victoria, along with the people that gave us marriage equality, are now have just started a campaign to institute legislation giving effect to that identity. So we, as Transgender Victoria, conducted a campaign with the Labor government in Victoria to give us the right to change our identity on our birth certificates on the basis of our sworn affirmation, in the same way that you can change your name on your birth certificate on the basis of just an affirmation, a sworn affirmation. That failed by a single vote in the upper house. The upper house vote was tied. It was passed in the lower house. But the AME, the Australians for Marriage Equality, and other organisations are coming back on a national level and saying, we want this sort of legislation across the country. We want the ability for people to decide that they're neither male nor female. We want the ability for them to change their gender. We want that whole forced divorce before changing your gender on your birth certificate. We want that removed from all states. It has to be removed by the 9th of December. We want it removed earlier. So they're running going to be running quite a vigorous campaign into legislators, and that to me is exciting. And this piece of legislation is just something that you can wave. Well, India can do it, Nepal can do it, Pakistan can do it, and 14 other countries across the globe can do it. Why can't Victoria? South Australia's already done it. So, this just adds weight to that argument. So I'll close there and look forward to the discussion. Thank you.
Thank you very much, Michelle, and thank you very much also for your acknowledgement of the country. I think it was very eloquent. And also kind of suggests to me the shared colonial histories between India and Australia, which is something that I think is important to recognise, to think with when considering legal transformations vis-a-vis gender and sexuality in different parts of the world. So kind of taking off from the central question that we are approaching this court case with, I think it was what can the Indian case tell us about transgender rights in the rest of the world? Sorry, I'm like butchering that. But I'd also like to think about the ways in which the Indian case presents ways in which developments in India and in other parts of the world is actually constitutive of the meanings of transgender itself, and is shifting what transgender means, both as a legal category and kind of as a lived experience as it takes place in disparate locations globally. And I think, as Michelle nicely pointed out, there's kind of always room, I think, to think about the context in which these categories take form. So transgender takes form in this instance. While there are varying languages and categories, ways of thinking with gender and sexual difference globally, those are always kind of hinging on or based around particular locally and nationally specific scenarios. So that pull kind of between the kind of universalizing aspect of say a category like transgender, which travels around the world, and its kind of implications in diverse local and national contexts, is something that I kind of would encourage everybody to take up. So at the same time as these kinds of transgender grows in prominence in different parts of the world, there's also an emergent field of study, transgender studies, that is kind of quite interesting and vibrant, and I think is able to offer kind of different vocabularies with which to address these questions. So one that kind of strikes me as relevant to this scenario is a special issue by Transgender Studies Quarterly, which is kind of a major kind of forum for transgender studies globally, on decolonising the transgender imaginary. So it's ways to think through both the implications of using transgender in diverse settings, right? And also thinking about the ways that it may kind of reproduce or resist colonial contexts in those diverse settings. So with that in mind, I'd just like to talk a little bit about my own work. So I work in another country, so again, not India, but Indonesia. So Indonesia, are many people here familiar with Indonesia? Sorry to introduce kind of more facts and figures. But was colonized by the Dutch and kind of underwent a long process of colonization until around the end of World War II, when Indonesia was declared a nation, and it was bounded together by a national language, I guess, and brought together thousands of islands of a disparate archipelago, right? Quite a kind of unlikely nation, I think, in the words of some observers. But nevertheless, Indonesia clearly persists as a nation, and indeed has its own national categories for gender and sexual difference. So the one that I have been most involved with is a fairly well-known, visible category of, I guess, transgender identified people, known in Indonesia as waria, which is wanita and pria. It brings together the words for woman and man, right? Basically as like a portmanteau or a neologism. So waria, it sounds very kind of exotic, it sounds very intriguing, but it's quite a new category. It was declared by the Indonesian state in 1978. So I think that this to me brings to mind the way in which categories of gender and sexual difference globally can also have relatively recent histories, right, that hinge on the specificities of national contexts. So with regards to waria, which has kind of emerged as a form of transgender femininity, you might say, waria say, or tell me in the course of my research, that they emerged for the first time around 1968 at the beginning of a new regime, what's called the New Order regime, which granted them a level of visibility and recognition that they hadn't had previously. That enabled them to, as they say, be seen or express themselves for the very first time, right? So there may be kind of resonance or a certain familiarity with that discourse. Through that process, waria were able to access various social services. They were granted, as I say, the term waria in 1978, which was very important to them. And through that, they were able to kind of mobilize, be visible, be seen, gain recognition in different spaces, right? Both bureaucratic and socially. So they say things like that for the very first time they were accepted, right? That visibility offered them a degree of acceptance in society that was previously not present, right? So not to contest waria's narratives, but I'm sure the history is a great deal more complicated than that. But nevertheless, it's to say that national recognition has been important to the formation of waria identity. At the same time, I think it's really important, so waria's emergence, while really important and interesting, is something I think that we need to approach with a degree of capacity to critically engage with. So I think that the essay in the Transgender Studies Quarterly special issue that I'm thinking of that deals with India by Dutta and Roy suggests that certain hierarchies of scale can emerge through a process of national categories of identification. So waria might come to stand for all kinds of different experiences that don't necessarily fit with how those people feel throughout the nation, right? So, and in Indonesia, you of course observe that, right? You have people identifying in many different ways. People may identify as gay, people might identify as lesbian, people might identify as priawan. There are multiple different categories for gender and sexual difference. So I think it's really important to bear in mind while say, for example, in the Indonesian case, Wadia may have allowed kind of great strides. We also need to bear in mind the way in which these are also hinging or dependent on colonial and post-colonial histories. So in recent times, so just to kind of narrow in again on the Indonesian context, and I apologise for that. So the past 2 years have been kind of a terrible 2 years for LGBT rights in Indonesia. I think people might be aware of that. So Indonesia in 1998, I've mentioned the kind of emergence of an authoritarian regime in '68. That authoritarian regime kind of toppled in 1998. And what's happened in the aftermath of that has been kind of the emergence of a really vibrant civil society, but also the emergence of all kinds of reactionary politics. I don't think that I can go into detail about the complexities of that right now, but what is really interesting and also terrifying is the way in which gender and sexual minorities have become a target for all kinds of blame and anxiety about the state of contemporary Indonesia. So just to add another kind of example from the Indonesian case, last year there was a court case in the Constitutional Court brought by a group of Indonesian citizens, a civil society group, that lost, I think, 6-5, that attempted to criminalise all kinds of gender and sexual difference, right? In a very broad way. So basically, any sexual relationship outside of marriage, any gender presentation apart from strictly heteronormative gender presentation would be outlawed. So bringing kind of basically the majority of Indonesians, you might say, into its remit. And that only that almost passed, that almost got by, to me is a very worrying sign. And it shows the need, I think, for all kinds of solidarities in Indonesia, but also globally, that link together, say, transgender and LGBT rights with other kinds of movements to engage these kinds of politics. But I think I'll leave it at that. Thank you.
Thanks so much. You have given me all given me so much to think about already. I'm gonna just try to draw together some of what everyone else has already said and sort of frame it within the context here in Victoria and in Australia as well. So it's certainly been the case, historically and cross-culturally in all kinds of research that we've always known, and we can gather really from common sense that people have always transgressed what's expected of them in terms of their gender, right? That people haven't always just lived according to what are the stereotypes expected of them in their gender categories. So that has, people have done historical research and cross-cultural research that always shows this, and that has affirmative repercussions for a lot of people, right? Like this decision can as well. And I think one of the sort of key kind of historical issues to take account is when, those differences became pathologized, which was in the early 20th century, through sexology, sort of science of sexuality, that this was a time when to be different sexually, to have a different kind of gender was made into a psychopathology. And I think that this is a really key moment, and it's the consequences of that we're living with now. Certainly, in Australia, it's still a pathology to have a different gender, so to be transgender is a pathology. It's listed in the Diagnostic and Statistical Manual of Mental Disorders, which is used by Australia to categorise people like us as mentally disordered. So this is the context that we're living under. It's also the case for intersex people, so people who are sexually different in their sex category, as opposed to transgender people who are different in their gender category. So intersex people, they're also pathologised through the category disorders of sex development. So I think thinking about the ways that those medical frameworks, my own research is in medical anthropology, have framed these legal discussions is really key. So for instance, the way Jeff sort of described that decision really drew its boundaries really strictly about saying this is about gender, this is not about sexuality. The same thing has certainly happened in this country. So for instance, when trans people were first able to marry through a High Court decision in 2003, I think it was Kevin, when the first trans people sort of took to the High Court the ability to marry, that was a really heteronormative decision. So it was really based on trying to draw boundaries between what was a same-sex relationship and what was an opposite-sex relationship. So trans people had to prove that they were part of this opposite-sex category in a whole host of different ways to show that their marriage was still a heterosexual marriage, that it was an opposite-sex marriage. So I think the way that those boundaries have been policed and continue to be policed are very often in this way, of drawing categories between what's heterosexual, what appears to be heterosexual. Definitely. So I thought I would also just talk a little bit about, I had one other point when Jeff sort of said that, that they had this kind of idea where committees would decide on your gender. That is what happens to people in Victoria. It is what happens to people in Australia. You have to go to a professional, a host of professionals, and beg them to give you the designation of the gender that you prefer, that you feel best describes you, and a committee of people then decide together whether they think that's appropriate or not. That is what happens here. So I was just going to go through a couple of other things in terms of thinking about, I do think that law and legislative and court decisions are really important. They do give us really important kind of avenues to pull into particular kinds of political changes that we might want to make. But they certainly don't, as Michelle and Jeff have pointed out, make those things happen. I mean, we have this same-sex marriage now, and that hasn't obviously ended homophobia, like a lot of people hoped that it would. But it's also the case that, as Michelle sort of alluded to, so in Victoria, if you're married, you can't transition, you can't change your sex legally if you're married still. And a part of that, the reason that there was that sort of facet of the program was so that same-sex marriage, because same-sex marriage is illegal. So you couldn't have someone who was in a heterosexual marriage who transitioned, because then you would have a same-sex marriage. So even though now we have same-sex marriage, trans people still can't they still can't be married and transition. They still have this problem. So yeah, I guess I'll just briefly go through a couple of the other things that trans people are sort of subjected to here in Victoria. So for instance, in order to change sex legally in Victoria through the Births, Deaths and Marriages register, you do have to not be married. You also have to have had sex reassignment surgery, which I noted in this decision that we're talking about. They said any insistence for SRS, sex reassignment surgery, for declaring one gender is immoral and illegal. So that is the context that we're living under here, that people have to have had that surgery and multiple surgeries in order to prove that they're not reproductive, among other things. So the Births, Deaths and Marriages register also says that no history of the change of your sex will be listed on your birth certificate, and that's great, but the name that you're born with is listed on your birth certificate. So if you want to change your name at birth will still be visible on your birth certificate. So, that doesn't really help for most people who aren't born with gender neutral names. It also costs $100. It also costs $100 to change your name, and you can't do them together. So it costs at least $200 to change your sex and your name. If you get married, it's free to change your name. If you get divorced, it's free to change your name. But if you're trans, it costs you $200. You're also only allowed to change your name 3 times in your lifetime. And for me, I've already changed my name twice. I changed my name once when I was 18 to a kind of gender neutral name, and then I changed my name again when I transitioned. So if I get married and want to change my name, then that'll be my 3rd and final change that I'm allowed to make to my name. And there's provisions kind of in that list that say a reason for which people might be able to exceed the 3 times in their lifetime changing of their names is via marriage. So if you're married and divorced 5 times, you can change your name 5 times, but not, if you have other gender-related reasons that you might have changed your name. So I think I'll just wrap up with a couple of things I think it should be, free and easy, as is outlined in this Indian decision, to sort of change, your name and your gender and the other categories. It's extremely difficult and time-consuming and expensive. Pretty much every single piece of identification you have to buy a new one. No one will ever give it to you for free. And also that we need for, both intersex variation, so disorders of sex development, and, transgender people, so, gender dysphoria, to be unpathologized. We need them to not be pathologies. And yeah, I'll just leave it